From the National Constitution Center in Philadelphia, this is We the People. I'm Julie Silverbrook, Chief Content and Learning Officer. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. On February 28th, President Trump announced major combat operations in Iran. The operation, known as Epic Fury, has renewed a long-standing debate about the scope of presidential war powers and who has the constitutional authority to decide when the nation uses military force. In this episode, we explored the constitutional foundations of war powers, as well as the War Powers Resolution of 1973, examining how they inform today's debates over the respective roles of Congress and the president. To help us explore this history and the current debates, we are joined by two leading scholars of constitutional and international law. Harold Koh is the Sterling Professor of International Law and former dean at Yale Law School. He is a leading expert in public and private international law, national security law, and human rights. He is the author of many books, including The National Security Constitution, which traces the evolution of the constitutional struggle and balance of institutional powers in foreign affairs and national security policy across American history. Harold, welcome to We the People.
Good to be here.
And Michael D. Ramsey is the Warren Distinguished Professor of Law at San Diego Law School. His scholarship focuses on the constitutional and international law aspects of U.S. foreign relations, particularly in the areas of war powers, treaties, and presidential authority, as well as on the litigation of transnational claims in U.S. courts. Michael was a contributor to the NCC's interactive constitution on the clauses that we'll discuss today. Michael, welcome back to We the People.
Well, thank you for having me.
All right, Professor Koh, I want to start with you. We are in week 2 of U.S. military operations in the Middle East. And last week, Congress rejected legislation that sought to require President Trump to obtain congressional approval for military actions against Iran. Could you help set the stage for us? What are the actions the president announced, and tell us about Congress's response so far?
Well, the president launched an attack on Tehran in conjunction with the Israelis, and that ended up killing the leader, longtime leader, Ayatollah Khamenei. He has now been replaced by his son, Ayatollah Khamenei Jr. But meanwhile, the response has led to the conflict spreading to 7 other different countries. At this point, we're almost 2 weeks in. We don't know how long it's going to go. Congress said it won't stop it, but it doesn't say anything about how long it ought to last or even what the goals of it are. We're in a peculiar situation because the president is saying it's not a war. Because if it was a war, Congress would have to declare it. But at the same time, he says that the objective is regime change, that he will not stop until there's unconditional surrender, that if the Iranians resist, he'll use massive force, which raises the question, then what does it mean for Congress to have the power to declare war if they won't exercise it? So this, in the book that you mentioned, The National Security Constitution in the 21st Century, is really a 3-branch problem. American presidents have, and particularly in the last 25 years, seized more and more power to use force unilaterally. Congress, whose power it is over war-making, has simply let it happen. And the courts, who were supposed to be a check and were a check early in the Republic, have largely absented themselves from this landscape. And so we're now, ironically, in a situation where it's much easier for the president to use force abroad on his own whim than it is to make a treaty or to engage in negotiations. And so it's become an instrument of first resort and not an instrument of last resort. The War Powers Resolution, which we will get to, I think played a significant role, but it's now more than 50 years old, and it's clearly not serving its purpose anymore. So this is a problematic state of affairs.
I want to, for our listeners, explain the state of affairs. So President Trump did submit within that 48-hour time period under the War Powers Resolution a report to Congress. Congress doesn't take action. Can you walk our listeners through the legislative activity or non-activity that happened last week?
Yeah, under the War Powers Resolution, the president is supposed to notify Congress ahead of time He did give a notice to the so-called Gang of Eight, the congressional leaders, which is frankly more than he's done in other kinds of operations, more, for example, than he did with Venezuela. That's supposed to give them time to respond and decide whether they approve of the operation, whether they want to set limits on it, etc. It also allows them to consider any resolution disapproving the action, which is supposed to be put on a fast track and come up for a quick vote. Such resolutions of disapproval were, in fact, then introduced, and those were the ones that were voted down, again, with the Republicans on the Senate side providing the key votes. So at this moment, the president is able to conduct this war largely unimpeded by Congress. Congress does have one more shot at this, which is when it comes to the question of whether to fund the operation and keep it going. And they have the ultimate power of the purse, but they have not enforced that power either, which is remarkable. The president has done all kinds of things in this administration to not spend money that Congress has appropriated, to get rid of agencies that Congress created. So if Congress doesn't stand up for its own core constitutional responsibilities to spend money and to declare war, there's not much that others can do about it.
Well, let's get into that a little bit on the constitutional pieces and anchor our conversation in the text of the Constitution itself. Michael, I'd like to start with you. Article 1 of the Constitution gives Congress the power to declare war, while Article 2 names the president commander in chief. How did the framers understand the division of authority between Congress and the president when it comes to military force?
Well, thanks, Julie. And the short answer, in my view, is that the Constitution's original meaning through the Declare War Clause gives Congress and not the president the power to decide whether to use military force or whether to initiate military force against a foreign nation. The commander-in-chief power gives the president some residual power over military actions that are not wars, because Congress has war power. But the war power lies entirely with Congress. And to elaborate on that a little bit, it's a little confusing, I think, to modern readers of the Constitution, because Congress has the power to declare war. And we think of declaring war as being an official pronouncement like we did back in World War II, but we don't really do anymore. But I think the meaning in the founders' era was broader than that. Going all the way back to John Locke, who said that you could declare war by, quote, word or action. And there's many instances of this usage in the 18th century where they would say that a war was declared simply by launching an attack. And that predated the Constitution. It was picked up, I think, in the Declare War Clause. And then if you look at the way the founders described the Declare War Clause, they clearly saw it as giving the power of war initiation to Congress. So you had, for example, James Wilson in the Pennsylvania Ratifying Convention explaining the Constitution, saying that under the Constitution, it would not be in the power of one man to bring us into war. And he pointed to the Declare War Clause as accomplishing that. And later, Alexander Hamilton, who was, of course, an advocate of strong presidential power, but even Hamilton acknowledged and pointed to the Declare War Clause as a limitation on the president that would prevent the president from starting military conflicts with foreign nations. So I think that the original understanding of the Constitution on this point is quite clear. There is some gray area. There's gray area about the president's ability to respond to an attack on the United States on his own authority. There's gray area about the ability to use military force in situations that are not the use of military force against foreign nations, but against non-state actors, for example. So there are some gray areas, but I think there are some very clear areas. And one very clear area is that the Constitution assigns to Congress and not the president the power to decide whether to initiate the use of military force against a foreign nation.
Harold, do you read the constitutional structure in the same way And if you do or don't, how should we understand the relationship between Congress's power to declare war and the president's authority as commander in chief?
Yes, Mike reads it correctly. We have originalist Supreme Court, as your podcast points out repeatedly. So this Supreme Court ought to be very skeptical about this perversion of the original design, which is sharing power. The problem is that the courts too often remove themselves from this by saying that nobody has a capacity to challenge an action. They don't have standing, or it's not ripe because it's too early. The challenge comes too early, or it's a moot because the challenge comes too late, or that it's not something that the courts have relief to grant. So, in other words, an illegal action can persist and be replicated over and over again without the courts taking a stand. And I think that's extremely problematic. I really do think that the key issue is how can Congress let its core powers be invaded and do absolutely nothing, and then claim still to be doing their job? We have only recently read the Supreme Court's decision in the tariffs case, where 6 justices said very definitively that the power to impose tariffs is Congress's, not the president's. Nevertheless, for 14 months, the president exercised this tariff power unilaterally, and Congress did absolutely nothing to protect its own power. That opinion should mean that they were tolerating illegal behavior by the executive branch that invaded their core priorities and did absolutely nothing. And that's just basically a disgrace.
So a recurrent theme for across constitutional discussions, which is basically Congress, where are you? Maybe we'll do a whole podcast episode across the many areas in which congressional action may be warranted across American policy areas. I do want to come back to a key question in these debates about what counts as war in the constitutional sense. Michael, you've written about this, including for our interactive constitution. How did the framers understand that term, war, and what kinds of military actions did they believe required congressional authorization?
Yeah, that's a great and important question, because I think the executive branch doesn't seriously challenge, I don't think, the interpretation of the Declare War Clause that I gave and that Harold agrees with, and that Congress has the power over war. But I think the principal executive branch argument is that these uses of military force, and it's not just Iran, but the long-standing for the past 30, 40 years of the president using military force without congressional authorization, is that, these aren't wars. They're low-level conflicts, but they're not wars. And this was the justification that's been given for going all the way back to the Reagan administration, Grenada, Bush administration in Panama, the Clinton administration in Yugoslavia and Kosovo, the Obama administration in Libya. All of these, the president says, this is not a war, so it doesn't trigger the need for congressional authorization. So in my assessment, under the original understanding of the Constitution, this is not a valid argument, because as I see it, the founding generation read war very broadly. If you look at a dictionary definition from the time, it's very broad. It says it's just the use of sovereign force against opposition. It doesn't talk about the level of resistance or the level of casualties or the duration or anything like that the executive branch cites and its attempts to say that things are not war. And then if you look at the practice right after the Constitution, there were 2 significant uses of military force. The 1798, the naval war with France and the Adams administration, and then the similarly naval campaign against Tripoli, this modern Libya, under the Jefferson administration in 1801. And these were understood to be conflicts within Congress's war power, even though they were relatively low-level uses of military force. There were not full-scale engagements by the United States either time. There was some debate on both of them about the extent to which the president might have the authority to respond to attacks. And as I mentioned, that's a gray area in war powers. But nobody to my knowledge at all argued that Congress's war powers weren't implicated because these were not wars in the constitutional sense. And yet, I think by the standard the executive branch is used to justify its various unilateral uses of the military that I mentioned, including running right up through Venezuela and Iran, then these wouldn't have been considered wars either. So I think that to the contrary to the executive branch understanding, the original understanding of the Constitution was that war was quite broad, and it meant the use of military force against a foreign nation. It may have meant some other things beyond that, but at minimum, it meant the use of military force against a foreign nation. And so I think that is the original understanding. I do want to say quickly that everything I've been saying is just about the original understanding. And if you want to take an originalist approach to it, that should be quite important to you. But originalism is not the only way that people have approached constitutional interpretation. In fact, it was quite a minority view until fairly recently. It remains quite a minority view within legal academics. And if you look at this as a evolving constitution or living constitution approach, as opposed to originalist approach, you have a very different set of arguments. And the president is, in my opinion, on much stronger ground there. So I'm just saying, in response to your questions and echoing my principal scholarship, because that's what I do as a scholar, is look at the original understanding. Whether that's the binding law today or not is a different question.
That's a perfect tee up. And before we get into modern practice, Harold, you, of course, have the unique background of having been in a presidential administration during action in Libya under the Obama administration. And I did want to get perspectives from you on how flexible the constitutional framework should be when we're applying it to modern conflicts where the military actions often fall short of formal declarations of war, either because it's of limited duration or because Congress doesn't actually formally declare war.
Well, 2 points at the start. First, I am not, unlike Mike, an originalist. I am a living constitutionalist. But even so, there's a limit to how much the president can reshape the Constitution to eliminate checks and balances. And even if he does so with the acquiescence of the other branches, that doesn't legitimate such a departure from the original design. After all, one of the objections at the Declaration of Independence, which is 250 years old, made was that the king could take us into wars that impoverished the people on a whim. And the president was not supposed to have that power. That's why those checks and balances were introduced. Second thing is we have to read these things in light of current events. These things didn't just happen. The president just lost the tariffs case. His popularity is at an all-time low. In that moment, the Israelis are pushing to act, and he decides that this is something he can do that can push this out of the headlines. And that certainly has happened. This is now the subject of debate, and it's very clear that they have absolutely no agreed upon rationale for the reason for entry or the exit strategy going out. For example, if they originally were arguing that this was not war, it was self-defense. But previously they had argued that use of bunker buster bombs had obliterated the Iranian nuclear threat. So how could it then be self-defense? Now, I served in 4 administrations in 5 different decades. So there have been many, many episodes that I've been in the government for. And the president certainly does have some interpretive power. But it's also clear 2 other things. One, that major wars, for example, the Iraq war of George H.W. Bush was approved by an authorization for the use of military force. Mike is correct that declarations of war have pretty much stopped, but there are authorizations for the use of military force by which Congress is forced to vote and put itself on the line. Secondly, because the War Powers Resolution applies to the commitment of armed forces for more than 60 days in the air, sea, or airspace of another country, that has driven presidential activity into unregulated zones. So increasingly, we see actions by people who are not U.S. forces. We see actions by drones, which are not forces. We see actions by special ops teams that take less than 60 days. These are things that are in the interstices of the law. And with artificial intelligence and cyber commands going forward, more and more will be put into these quick hit spaces, which is exactly where this administration likes to be able to act quickly. They're only using air power. Nevertheless, they suffered 7 fatalities so far of our troops, plus hundreds of Iranian civilians in a school that was hit on the first day, which the president is now denying was hit by a U.S. Tomahawk. So um, uh, in Libya, you brought that example up. It's a good counterexample. Number one, that was approved by a unanimous UN Security Council resolution. There's nothing here. Secondly, the initial entry wasn't objected to. Third, by Congress or our allies. Third, the U.S. Initially used force to set up a no-fly zone, and then through the agreement of President Obama and our NATO allies, switched to a supporting role, where it was essentially flying support missions. So there were virtually no bombing by the United States after day 15. And so there was a decent question as to whether we were in active hostilities at that point. And then finally, obviously, the operation succeeded. So, you can't just say, as the Trump people like to do, well, others did it too. They didn't do it on this scale. They didn't do it with this kind of twisting of language or history. And they didn't do it with this kind of contempt for the law and the constitutional design.
Let's get back into the statutory framework in the modern era, because we've mentioned the War Powers Resolution. We've talked a little bit about these other congressional authorizations called authorizations of use of military force, or AUMF. Harold, can you walk us through what the War Powers Resolution is, what prompted Congress to pass it? They actually passed it over President Nixon's veto, and what responsibilities it places on presidents who introduce U.S. forces into hostilities. And you started to get to this a little bit, which is, there's sort of areas that are vaguer and therefore the facts really matter. And I want to get into that too, but I want to take a step back for our listeners who are maybe less familiar with what the War Powers Resolution actually is and how it functions.
Yeah, so the War Powers Resolution is the major existing statutory framework convention in the area. In other words, in the law that makes up what I call the National Security Constitution is not just the few provisions of the Constitution, the Declare War Clause, the Commander-in-Chief Clause, but it's also the way that Congress has mapped out the space with a resolution. And after Vietnam, to prevent future Vietnams, Congress enacted this resolution, which said that notification and consultation were required before troops were committed. And then in 60 days, which could be extended, the president needed to withdraw the troops or get approval from Congress in the form of a statute, namely an AUMF. And it also provided for a legislative veto where Congress could, demand that the troops leave. And it also set up various processes for expedited legislation. Even at the beginning, there were weaknesses in the way the legislation was adopted. And as you say, it was adopted over a presidential veto, so by 2/3 of both houses. The major an obvious defect was that it did not specify when the president could not put troops somewhere for even 10 minutes, which means the president has the freedom to put troops or military forces into play for up to 60 days before Congress is acting on the resolution. And obviously, once you get in, you change the status quo, and this makes a huge difference. Secondly, the Supreme Court in 1983 struck down the legislative veto provision, which was one of Congress's main checks. And then third, and I think most important, we have to acknowledge that the War Powers Resolution operated based on a deadline. The real goal was interbranch discussion between Congress and the president about why troops and military force are necessary and what the end state goal is. But the way that they were trying to promote that discussion was by a 60-day deadline. The problem, as you know, is that deadlines only work if people treat them as real deadlines. And what's happened over time is the president ignores the deadline. Congress agrees to, they don't care about the deadline. And then the courts are claimed to be disempowered from enforcing the deadline. So there's no deadline. And if there's no deadline, there's no discussion. And so it has not succeeded in what was a noble goal. And then finally, the point that I made earlier, the regulation has had the effect of driving military activity into the unregulated areas. So instead of use of armed forces, you have covert action or non-human actors like drones. Instead of 60-day or more Vietnam-like interventions, you have short hits like special ops, like you saw in Venezuela with Maduro. You have use of cyber war, which obviously is no physical presence of anybody in the land, sea, or airspace of another country. So increasingly, the War Powers Resolution is just technologically obsolete. It's not going to achieve its goal. It does have a moment yet to come in Iran, which is if and when we're there for more than 60 days. And right now we've been there for about, 14 days.
I want to bring Michael back in to get your perspectives on the War Powers Resolution, which was an attempt to try to actually sort of bring back the way that the Constitution had intended to allocate war powers in some way, to give Congress a role even for some more limited military operations. I want to ask you if you think it successfully enforces the Constitution's allocation of war powers, or does it actually raise some constitutional concerns of its own? I think Harold has done a good job of pointing out the practical challenges that the War Powers Resolution has introduced into this murky area with the president and Congress.
Yeah, thanks. I largely agree with what Harold said. And though I would say that the War Powers Resolution was misconceived from the beginning in a couple of respects. I think it's both too restrictive and too permissive as to the president's use of force. So in the first place, it purports to limit the president's use of force, I think, more broadly than Congress probably can, because it doesn't limit itself to actual war situations, notwithstanding its title, but it purports to limit the president's ability to introduce military forces into, quote, hostilities, a term that it doesn't define, and which could go considerably broader than what I see as the core constitutional limit on the president, which is that the Congress has to authorize the initiation of military force against a foreign nation. This isn't relevant to the discussion of Iran or the other situations that we've mentioned, but it's important because it's allowed presidents to claim that the War Powers Resolution is unconstitutional in the respect in which it limits the president's power. And I think that's true to some extent. And I think that the Congress should have been more careful in defining the situations in which the president's ability to use force is subject to congressional limitation. But at the same time, I think the War Powers Resolution is too permissive, largely for the reasons that Harold's already stated. That its only operative section really is to say that after 60 days, or actually it's 90 days if the president certifies that it's a national emergency, which the president always will, then Congress has to approve. But this appears to give the president a window in which to use military force for 60 or 90 days, and without limitation from Congress. And presidents have aggressively used that, and with some plausible argument that they have Congress's acquiescence to use military force in that window provided by the War Powers Resolution. And there's nothing in the Constitution that suggests that a short duration use of force is within the president's independent power if it's a war. But the War Powers Resolution seems to suggest that. And then as a practical matter, again, as Harold said, and I'm entirely on board that in the modern day, the presidents can do a lot of damage in 60 or 90 days. And that's giving them a latitude that they shouldn't have under the original understanding of the Constitution. But again, just to go back to the point about living constitutions, the problem with living constitutions or evolving constitutions is it's hard to know what counts as an evolution. And the War Powers Resolution, with its apparent authorization to the president to use force for 60 days, is part of that evolution, perhaps, and presidents will argue that gives them the authority. This is what happens when you get away from the baseline of the original understanding and start talking about how modern events may change our understanding, and it gives the president quite a bit more latitude. And I'm not a modern constitutionalist, so I don't have a worry there.
We'll come back to how this is all played out in practice. I know folks have a lot of questions about the War Powers Resolution and how it works in reality. So we have this 60, probably 90-day clock, right, for congressional authorization. What happens if Congress doesn't pass legislation either approving or blocking the use of force within that 60 to 90-day time period? What does the statute actually require?
Well, the statute requires, if Congress doesn't approve the action, that the president cease the hostilities and withdraw the forces. But the question is what actually happens once the deadline's passed. The first thing that may happen is that the president may try to take advantage of ambiguities in the language and say, now, he's going to have to scale back a lot in Iran before he can say this, but the presidents may say, well, this doesn't really count as hostilities. Remember, that's the critical word in the statute that's not defined. And so that happened with Libya, that I was going to say the hostilities, but the events outran the War Powers Resolution clock, and the president said, well, it's not really hostilities, and therefore I'm not in violation. So the president may take advantage of weasel words like that, and perhaps the president may just straight up defy it. We don't know what will happen if the Iran operations go beyond 90 days. But again, as Harold says, and I entirely agree, both descriptively and with the normative implication, that the problem is that the courts are not going to enforce the statute because courts are extremely reluctant to get involved in disputes over war powers, and so I don't think we can expect anything from the courts. And if there were an extension of the Iran situation beyond 90 days, I think, again, as Harold says, it would be entirely up to Congress to enforce. And I would assume that if there were to be an enforcement, it would come through a cutoff of funding, because that's the thing that Congress really has most effectively at its control.
I want to shift from the constitutional and statutory frameworks to looking at how this is played out in practice. And Harold, you've already started talking a little bit about this. Since 1973, presidents of both parties have engaged in military operations without prior congressional authorization. Can you walk us through some episodes, from the sort of post 1973 War Powers Resolution era, where presidents have engaged in those military operations, when you think they are sort of within the limited military operation, not requiring congressional authorization, or either through the War Powers Resolution or an AUMF, and those that are of sort of limited duration or limited scope and scale, that they would fall sort of outside the need to have that?
Well, there are so many incidents, but hundreds. But I think the basic rule is that under the current framework, for 60 days, if it's not a war in the constitutional sense, then the Congress is tolerating the action. If it goes past 60 or 90 days, then Congress is supposed to authorize it. But if they don't authorize it, then it's an unauthorized action. So it goes from being tolerated to unauthorized. But the president is increasingly saying, I am authorizing it under my constitutional power, and asserting more constitutional power to engage in war. So it doesn't matter whether it's unauthorized or not. And because of that, and because Congress and the courts have not objected to that reinterpretation of war-making power, the legal lines have been largely erased. And which is one reason why we've been in a state of virtually perpetual conflict since 9/11. And that's a longer period than World War II and then the Civil War. It's the longest war in American history. And ironically, you have Trump, who in his first term was adamant about ending forever wars. In fact, Obama, Biden, and Trump 1 were against forever wars. Trump 2 finds that wars are a convenient way to show strength and exercise performative militarism. So where we're at now, Julie, is there are two political red lines. And those are the ones that are actually controlling the way these are being conducted. Number one, use of American air power, no boots on the ground. Because if you put boots on the ground, there's a risk that American soldiers will come home to Dover Air Base. And that makes wars extremely unpopular. What Trump has signaled is, look, the 7 people who've died already, that's just part of it. We're ready to take more. But apart from those 7 families, there's going to be more if there's more controversy. So he's resolutely kept troops off shore, both in Venezuela and Iran. The other political red line is that Congress never wants to have to vote. They don't want to put themselves on the record, because voting for a war, as we saw in 2003 in Iraq, is one of the things that can get you voted out of office. And Congress's priority is no longer enforcing its constitutional prerogatives or effectuating the Constitution, but getting reelected. And when you put those two political red lines together, that suggests that the president can conduct massive bombing with air power as long as he sustains relatively few American casualties. And Congress will let the war powers deadlines go by and not vote. And then the president conducts wars of increasingly large magnitude for longer and longer periods of time without restraint. For a first-term president, the restraint is loss of popularity and loss of capacity to get reelected. But for a second-term president, you don't have that political constraint. So I think that that's where we're at. And I think we have to deal with the political realities that have been created and how to change those political incentives going forward.
We've lightly touched, and perhaps it's because they haven't said much in this area, but what role have the courts played in the interbranch tension between the executive and Congress on the issue of war powers? Michael, I'll pose that one to you.
Well, I think the answer is the courts have not said much, and they really haven't had a war powers case since the prize cases in 1863 about President Lincoln's ability to initiate a blockade during the Civil War. And so that has not left us with a lot of guidance from the court. There were some cases relating to the war on terrorism during the W. Bush administration, but those mostly didn't go directly to the question of the authorization of the use of military force, because in the post 9/11 situation, there was an authorization from Congress for the president to use military force against the perpetrators of 9/11. And pursuant to that, the president, among other things, used force in Afghanistan. And so the courts have really not been helpful on this point, or at least they haven't been active on this point. And that has left it largely to the resolution of the political branches, which has worked out largely in the way that Harold describes. And I guess I would just add, though, that what I think you see there is an example of the living Constitution, that we have an originalist rule that has been undermined by successive actions by the president, by presidents, not the current president, not just the current president, but successive actions by presidents where the courts have not done anything, and Congress has largely not done anything. And this has become part of the constitutional evolution that's brought us to the stage that Harold describes. And again, that's why I would prefer to see more recurrence to the original meaning of the Constitution rather than appeal to what's happened in modern times. But the president has, in my opinion, a relatively strong argument based on prior presidential practices, if that's the kind of thing that you think matters for constitutional meaning.
So let's start closing our conversation. I'm going to ask two questions. The first is stepping back just from the current moment, right? The current military hostilities in Iran. How does Congress take some authority back in this space? And then what should the American people keep in mind? Michael, we'll start with you.
Sure. Well, those are difficult questions. And the problem is that any prescription here is going to require a certain amount of fortitude from Congress that may actually not exist. But assuming there were such an interest in Congress, and assuming that Congress doesn't want to vote down the Iran intervention, I think an interesting first step would be for Congress actually to approve the Iran intervention. I think that Congress would have basis for doing this, citing the long history of Iran-sponsored terrorism against the United States and other countries, and say, yes, we approve this because it is our authority to approve it, and our approval is necessary for it to go forward. So I think if Congress doesn't want to disapprove, at least I'd like to see Congress do something affirmative. And this is a way of asserting a power that isn't going to bring Congress directly into conflict with the president right now, but it puts something on the record to say, we understand, we Congress understand that this is our responsibility and we are going to take it. So, sort of a big swing by Congress would be to disapprove. But I think a more modest but somewhat effective first step would be actually to approve. The other thing I think is that assuming that the actions go forward for some time and funding becomes significant, then Congress is going to have to decide how to use its funding, whether to use the funding in support or to use the funding to limit the operation. And regardless of what Congress decides there, I think the most important thing is for Congress to be forthright and say, we are funding this affirmatively because we endorse it, or in the alternative, we are affirmatively cutting off funding because we don't. In other words, it makes less difference what they say than which way they take a stand. It's just take some kind of a stand.
Harold, what are your perspectives on that?
Well, the key point is this is a tale of three branches, and all three branches have to be reformed. Mike makes the point I was making earlier. If Congress wants to approve the Iran mission, then every member of Congress has to vote on how many people, American soldiers, they would like to see die in Iran. And then the question is, how many of Trump's strongest supporters voted for him so that their children could go to Venezuela or Iran and die? And my guess would be almost none. That's exactly why they're not having that vote, because they don't want to be responsible. They would let Trump be responsible, which is an abdication of their constitutional responsibilities. In my book, I have a long section on reform, but there are basically four ideas. One, get a group of foreign policy experts in Congress who form a core consultative group. It would be like the Joint Committee on Taxation. Second, to have a congressional legal advisor who could counter legal opinions of the executive branch by giving a more balanced perspective. Third, to link with expedited legislative procedures, votes to cut off of funding. And finally, to involve the courts more in these decisions by giving them a role to play more akin to what they played in the early days of American history. There are two decisions worth citing that are more recent than the Price cases. In 1990, when George H.W. Bush threatened to attack Iraq, there was a lawsuit by Congressman Ron Dellums called Dellums versus Bush. And the district judge there said, it's not ripe. I'm not ready to rule. But in principle, I could enjoin an illegal war. And that really threw the ball back to George H.W. Bush, which is you better get congressional approval. And after that ruling, he did go and get congressional approval. So it proceeded, but at least it proceeded without constitutional, not under a constitutional cloud. Secondly, there was a case called Ainge versus Bush, where they essentially said that if an American soldier is under orders to report to the war zone, they have standing to challenge an illegal order. And so they think they're being asked to fight an illegal war. The court can hear that case and say whether the war is legal or illegal. These interpretive questions, is it a war or is it not a war, is not any more difficult than many of the constitutional questions the Supreme Court decides. So their unilateral abdication and removal of themselves from this area is also unjustified. A final point goes to the responsibilities of the executive branch. Until now, we always had a president who had some sense of law and some sense of self-restraint. And that president, Richard Nixon, who obviously was not a good president, resigned after the Nixon tapes case. Here we have a president who has said to the New York Times, I am only constrained by my own sense of morality. And if you have a president who's not interested in carrying out his oath to faithfully execute the Constitution and laws of the United States of America, it's all the more incumbent on the other branches to impose those restrictions on him. Virtually any other president, if they had lost the tariffs case on the ground that they had invaded congressional authority, would have responded by saying, okay, so if I'm going to invade Congress's authority on war, I better be careful. I think this president's reaction was the opposite. I need to show my strength by doing the thing I know that Congress will never respond to, which is start bombing. And that leads us to a very, very dangerous place in our 250 years since the Declaration of Independence.
Let's end with the role of the American people on this. And Harold, I think you suggested this earlier, that this ultimately the checks here, because of how things have evolved with the constitutional practice, are political checks, right? Which ultimately have to do with elections. So what is the important role of the American people here?
Well, I think we have to remember that the Constitution was structured to prevent kings from taking us to war. War was supposed to be hard to enter into. It was supposed to be hard to enter and hard to sustain. And through this evolution we've discussed in the last hour, it's flipped. And it's become easy to enter on the say-so of one person. And it's become easier to sustain it as long as you use air power and keep U.S. casualties to a minimum. And with no clear objective on the other side. In Venezuela, we have the leader who is the vice president to the person who he took out. And in Iran, we have a leader who's the son of the guy who we took out. So what exactly is the goal? There is no objective, and they haven't agreed upon it. So I think the job of the American people is to say 3 presidents, Biden, Trump 1, and Obama said we were going to end forever wars. Trump 2 campaigned on that and went the other way. And the question is, that actually is something that we consider to be an important priority for our leader. Iran is costing $1 billion a day, and we're less than 14 days in. So $14 billion is being used for that. That's not being used for a million other domestic needs. And the question is that what people voted for? And if not, they have an occasion in November in the by-elections and also all the other elections coming along to send that message.
Michael, closing thoughts from you.
Well, I think first, one difference I have with Harold perhaps is that I would not make this debate or discussion principally about President Trump. I think that presidents necessarily try to enhance their powers, and we hope that the other branches and the Constitution will limit that, and that's our constitutional structure. So when you ask what can the American people do here, the first thing I would say is to try to abstract this from the debates over the Trump administration, because that just puts us back into the very sharp partisan divide that we have in the American people. When you make this about President Trump, then President Trump's supporters will rally to him, and President Trump's opponents will find lots of ways to disagree with him. And so I would ask the American people to take a step back from the Trump administration and go back to our founding principles and think about what the rules the Constitution sets forth. And then that's just my final pitch then is one for an originalist approach to the Constitution that provides some clear constitutional lines and try to go back to that, which I think is a very wise allocation of power and division of power between Congress and the president. And I think it's true here in war powers, but it's true in many other areas as well. And the problem is we've gotten away from that. And the result is that having gotten away from that, we find ourselves in a situation that we don't like, and we don't know how to get back. And so that's, I guess, where I would end is a call to go back to founding principles, not because we hate President Trump, but because the founding principles are the ones that ensure our liberty.
Quick response, which is, I think this is not about Trump. It's just that each president facilitates the next person who comes. And we are now getting to the point where we have someone who is almost what you would consider the endpoint. Dick Cheney, who was an extreme executive power advocate, was horrified by where Trump had led us. And secondly, this is not about polarizing between supporters and opponents. The question that's being directed to Trump's supporters is this what America first means? Namely, invading Iran, invading Venezuela. Is this what you voted for? And the question is, if it's not, then is this the administration that deserves your support going forward? Because what exactly is it standing for? So I do think the message is an important one. In interpreting the Constitution, the issue is not America first, is are we Americans first? And our founding fathers wisely framed this as let's make it hard to go to war, and let's have there be dialogue and discussion before we are committed to wars, which jeopardize everything else that are going on. And in particular, let's make it extremely hard to have perpetual wars. And if those are the core values at the beginning, they should be the values now.
Harold, Michael, thank you for a really interesting conversation. I think we ended in an insightful place for our listeners to think about the original understanding of the allocation of power between Congress and the president, how that's evolved over time. Harold, to your point, each successive president has pushed the outer bounds of their executive authority in this area, and the precedent set today will impact whomever comes next. And it's something for each of us to think about as we consider each successive military operation. I thank you both for joining us for We the People today. Thank you.
Thank you.
Thanks very much.
This episode was produced and mixed by Bill Pollack with production support from Charles Somm. Research was provided by Anna Salvatore, Trey Sullivan, and Tristan Worsham. In celebration of America's 250th, we have many exciting programs planned throughout this year. I want to tell you about two events that will take place later this month. On March 19th, Pulitzer Prize-winning historian and National Constitution Center semi-quincentennial scholar John Meacham joins to discuss his new book, American Struggle, Democracy, Dissent, and the Pursuit of a More Perfect Union. And on March 23rd, I'll be joined at the National Constitution Center by acclaimed historians Mary Beth Norton and Rosie Zagari to discuss how women's experiences and contributions deepen and expand our understanding of America's founding. This is the center's first in-person town hall of the year, hosted as part of our special America at 250 programming in Philadelphia. I hope you'll check out the full lineup and register to join us at constitutioncenter.org/calendar. Please recommend We the People to friends, colleagues, or anyone anywhere who's eager for a weekly dose of constitutional education and debate. And as always, remember that the National Constitution Center is a private, nonpartisan nonprofit, and we rely on your generosity, passion, and engagement for all of our programming, including this podcast. Please consider donating today at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Julie Silverbrook.